We'll hear from the appellant when you're ready.
Good afternoon, Your Honors.
Good afternoon.
May it please the court. My name is Jennifer McKinnish-Barton, and I represent Gerald Baker. He's the appellant in this case. And if this case sounds familiar, this is not the first time it's been to the Court of Appeals. I was not counsel at that time. I would like to reserve 3 minutes for rebuttal.
3 minutes, that'll be fine.
Thank you, Your Honors. As I stated before, this case has been on appeal before the Court of Appeals before. The immediate appeal before the court is rooted in a December 6, 2022 order by the trial court. There was a petition to modify spousal support that was filed by my client in October of 2021. We had a hearing November the 18th of 2022 in front of Judge McMillan in the Fourth Circuit Court here in Knoxville. And following a full hearing on all matters in that case, Judge McMillan issued an order on December 6th of 2022. That is a very detailed order, and in that order, by the trial court, the court found, among other things, that Mr. Baker was credible in his testimony. The court found that his retirement was objectively reasonable under the circumstances. The court also found a material and substantial change of circumstance existed from the prior orders of the court. And the court found that Mr. Baker would be in deficit based upon his monthly expenses versus that of Ms. Covarrubias of anywhere from realistically probably a $250 a month shortfall, but what could definitively be proven was around a $590 a month shortfall. So given all of that, the court, again, found that my client's retirement was reasonable, found that a material and substantial change of circumstance had occurred, found Mr. Baker to be credible, found that there was a deficit based on his monthly expenses when you take into account all of the evidence at the hearing, and yet the court failed to terminate or modify the alimony in this case. And so obviously, Mr. Baker agrees with the substantial and material change finding. He agrees that his retirement was objectively reasonable. Where we have the issue, Your Honors, is the fact that given all of the findings of the court failed to provide any relief to Mr. Baker from a financial standpoint. There's a number of cases that are very similar to this. A lot of times in doing the research, we found 2 or 3 cases. For example, the Malkin case that is cited by Ms. Covarrubias in her brief. There was Malkin 1 and Malkin 2.
Let me ask you something, counsel.
Yes, Your Honor.
It was a 50% of income that had to be shared, is that correct?
Yes, Your Honor.
And that's what the alimony was based upon?
Yes, Your Honor.
Now, wouldn't that be the same whether or not that income increased or whether it reduced? It would still be a 50%? I'm asking.
On an initial finding, yes, but when we go to a modification, the court has to take into account the needs and ability to pay of both parties. And so 50% when my client was employed and was making approximately $160,000 a year, and when the appellant had a need because she had never made earnings anywhere close to Mr. Baker, that was more than reasonable at the time. But in this case, 50% when it's only limited to Social Security earnings, that leaves him with such a shortfall that what happens on the modification is that actually Ms. Covarrubias has more of a monthly surplus than my client does.
But the initial amount was negotiated and agreed upon by the parties. Is that correct?
It was, Your Honor, but it was modifiable in this case.
Was that part of the original order that it could be modified?
The original order, which was, I believe, from 2007, doesn't really do a great job, in my opinion, of classifying the spousal support. It just says it's 50% of gross earnings. What was contemplated, obviously, was his earnings, not his residual Social Security retirement benefits, which is what he's now paying 50% of.
Did the original order say that, though?
No, the original order was vague. It just says gross earnings. And so there's some dispute over, Social Security retirement benefits actually what was intended by earnings. Our position would be when our client entered into that in 2007, I wasn't, again, the attorney of record, but that was his earnings, what he was making, what his actual, active income was, not what his Social Security retirement benefits were going to be some 20 plus years later. And so, Your Honors, this case is very similar. Like I said, there's a number of cases, Wilhoy and Malkin and some of the other cases where we have one or two attempts for modifications. And our position is this case is very similar to Will Hoyt too. And that's what I cited and relied upon largely in my brief. The only really big difference between the dentist in Will Hoyt and my client is in Will Hoyt, that dentist retained some of his liquidity. He had some liquid accounts, some retirement accounts and things of that nature. In the present case, Mr. Baker has liquidated all of his retirement assets to satisfy either the initial property distributions pursuant to the initial divorce way back in 2007, or there was a subsequent agreed order in July of 2020 where there were some contempt issues where my client has liquidated at this point everything he has as far as a retirement account in order to satisfy the obligations that had previously been entered into. And so what he testified to at trial in front of Judge McMillan was that he has basically nothing liquid left to draw on. There's not another 401k sitting out here or mutual funds or anything. He is living solely on this Social Security retirement benefits at this point, and he's having to give half of those to Ms. Covarrubias. And when he does that, that leaves my client with a little over $1,000 a month. And the testimony at trial was that he then takes what's left and gives it to his current wife so that she can satisfy as many expenses as possible.
We're looking, or the trial court was looking for whether or not there was a material change in circumstances from when.
Your Honor, that was one thing that was talked about early on in the transcript. Our position was that it should go from 2017 when the Court of Appeals remanded it to the trial court, and there was trial court back in 2015 granted Mr. Baker's modification. At the time, Mr. Baker was still actively employed with Kazai International, North American International, and Ms. Covarrubias appealed it. This Court of Appeals found no, there's not a grounds for a modification and sent it back to the trial court. Our position, it goes from 2017. Ms. Covarrubias is going to say, well, it should have gone from July of 2020. In July of 2020, there was an agreed order, but the content of that order addresses the there was some non-payment issues of alimony. And at the time of July of 2020, Mr. Baker was still receiving salary based on $160,000 a year. And so our position at trial, which the trial court agreed with, was that it goes back to 2017. Ms. Covarrubias' position is it goes back to July of 2020. I think in my reply brief, I said, well, even if you arguendos go to that July 2020 order, at that time, my client, Mr. Baker, was still receiving gross monthly income based on an annual rate of $160,000 a year. Mr. Baker then testified at trial that when he initially took a severance package, which he took the severance package in 2020, when he took the severance package, he hadn't really decided what he was going to do, if he was going to fully retire or not. And then he testified that during the period of severance and given some of the issues he was having with his hearing, that he elected that he could not go back at that point into the job he had been in, because at the time he was in sales, and his testimony at trial was that he didn't feel comfortable making big decisions when he couldn't hear well and he had this hearing loss. But our position is that the trial court got it correct, that there was a material change of circumstance, whether you use the jump-off order from 2017 or even from July of 2020, because even in July of 2020, he still had, at that time, Mr. Baker had over $6,000 a month coming in comfortably. Well, math's off. He had a monthly income based on his $160,000 a year at that time. And he did not begin to draw his Social Security retirement until the spring of 2021. And it was at that time that he then came in a few months later, and we filed the petition to modify his spousal support in October of 2021. One of the other things that we addressed in our brief that I'd like to bring before the court too is the trial court, not only did they fail to modify at all his obligation, which was 50% of his Social Security retirement benefits that's now going to Ms. Covarrubias, but the trial court was pretty silent when it comes to addressing the third-party adult that is living in the home of Ms. Covarrubias. And under TCA 365121, section F2B, where an alimony recipient lives with a third person, there's a rebuttable presumption that that third person is contributing to the support of the alimony recipient. And the trial court was silent as to that. There was testimony that there is an adult third party. It's the party's daughter. And I believe there may be a grandchild or two that are living in that home. And the trial court was assigned.
The child, the daughter living in the home prior to the initial setting the initial alimony?
Well, the initial setting of alimony, Your Honor, I don't know the exact age of the adult child now, but I believe she would have still probably been under 18 at that time, but she's an adult now. If my math's correct, that would have made her probably 16. I don't know her exact age, but I would think that she would not have been emancipated, or she would have been close to emancipation age at that time. But the court failed to take that into account at all with the effect of an adult third party in there. And under the statute, there is that rebuttable presumption that a third party adult's contributing for the benefit of the recipient. The other issue in this case, two other issues, when you look at the need and the ability to pay, is Ms. Covarrubias at this point is better off financially than my client. She has testified by her own, she didn't testify, but she submitted a financial affidavit, which the court accepted, and she has over $850 a month left over every month in surplus. That's even without taking into account if this third-party adult is contributing at all to the support. So she's actually in a better financial position in some ways than Mr. Baker.
Basically, what your client would be asking for is the termination of the alimony.
Your Honor, we are asking what we initially petitioned the court for in October 2021 was a termination of spousal support completely, or in the alternative, a reduction, given the fact that he is no longer drawing any kind of income. He is solely relying right now on his Social Security disability benefits on a monthly basis. And Ms. Covarrubias, at the time of the hearing in November of 2022, was still gainfully employed. There was testimony, as to her gross income, which was is employed, I believe, either the state or the county of Michigan. I can't remember. It's with the government. I don't remember if it's county or state. And so our position is that she's a better benefit than my client is at this point. Thank you.
Thank you.
You have time for a bubble. We're here for the appellee.
Good afternoon. Shelley Breeding from the Knoxville Bar here for the appellee, Kim Covarrubias. As this court knows, the trial court's decision regarding modification of alimony is reviewed on the abuse of discretion standard, and the appellate court should not second guess the lower court on this. And the trial court only abuses its discretion when it applies an incorrect legal standard, it reaches an illogical or unreasonable decision, or bases its decision on an erroneous assessment of the evidence. This case is limited to only a petition to modify alimony. It seems rather simple after the case that we just heard before this, but this is a fact-intensive question by the trial court. And first, the petitioner must show that there is a substantial material change of circumstances. But even when a petitioner meets that burden, it's not an automatic change.
The trial court found there was a material change in circumstances.
Correct, John. The trial court did. We disagree with that, and I'll get into that. But then the trial court must then go to the second prong, which is fact-intensive about whether or not a modification is appropriate. We have three issues before the court today. One is whether the trial court found that the substantial material change, that the trial court applied an incorrect or made an incorrect finding of law on that. It was a clear error of law. Secondly, that the trial court's fact-intensive analysis regarding the second prong, the propriety of the modification, was correct. And under that, there are kind of three sub-issues. One is that Mr. Baker was still able to meet all of his needs. Secondly, his alimony obligation, as this court noted, is self-modifying. And third, that the presumption that her needs had decreased was correct that the trial court did not make that, as this court previously rejected. And then our third issue is that Ms. Covarrubias should have been awarded her attorney's fees at the trial court level and should be awarded her attorney's fees on the appellate level. Looking at the first issue, the Mr. Baker had a significant hurdle in proving that there had been a substantial and material change of circumstance. And he has to prove both, substantial and material. Substantial is when it significantly affects either his ability to pay or her need. Material, which is what I think is at issue here, is that the change has occurred since the last time alimony was addressed. And in the petition to modify spousal support, when we're talking about that baseline is the 2017 order, the last time these parties were here, and I was here on that case, or if it's the 2020 order, which one is the appropriate time. The petition to modify spousal support that was filed October 25th, 2021, actually references the 2020 timeframe. In paragraph 6 of that petition to modify, it states petitioner would show that there has been a substantial and material change since the July 24th, 2020 order.
Well, when was the alimony last changed before this request?
It has not been changed at all.
At all?
Correct. He attempted, so the parties were divorced in 2007.
All right, then why don't we're looking for a material change from when?
Well, the last time it was addressed. And that's what the Malkin
It's just
2
addressed.
court.
I mean, let me ask you a question here. It's addressed, trial court says no material change. And then 2 years later, you know, it's changed some more, but you can't, you're stuck with whatever the trial court said wasn't just a material change. And
Well, the last time that the trial court said that there wasn't a material change.
I know, but additional things have happened.
I think they could have, but here.
For example,
Yes.
Income is $60,000, and he goes to $50,000 and files a petition to modify. Trial court says, no, that's not a material change. Mm-hmm. 2 years later, his income goes down to $40,000, or say it goes down to $30,000. Let's say 40. Then do you look and say, well, there's no material change from 60 or from 50?
From 50, because it
Really?
had already been.
Why?
Well,
The
because
trial court said that, I'm sorry, but the trial court said that's not a material change, but that didn't say it could never be considered. Trial court, the amount would be set at $50,000 a year, or his income was based on $50,000 a year, now it's $30,000 a year?
Well, I think that situation is a little bit different, and perhaps when the court is looking at the totality of the situation, the totality of circumstances, and what the current alimony obligation is in your scenario, based on $60,000 a year income, I think the court could consider it. But in this case, Mr. Baker received his severance in February of 2020. He started receiving his severance in February of 2020, and there is the order from the trial court in July of 2020 that addresses alimony. And at the hearing, he testified about the retirement. It's not just that his income changed. His income had changed a little then, but he knew at that point in July of 2020 that he had the severance and he wasn't going to go back to work. On page 40 of the transcript, he was asked by his counsel, explain to the court why you retired at approximately 62. Explain to the court, did you know when you took that severance package that you were never going back to work? Did you think you might work? Kind of walk us through your thought process when you retired a little bit early. And he answered on line 22 of page 40, they came to me with an early retirement. They basically told me to take it or else I'd be going somewhere else. So I took that. Question, so it was a forced retirement. It goes to the next page, or was it? And he said the document will not read that, but that actual case, yes.
Well, where's the proof that he wasn't going to go to work elsewhere? I don't see the proof. That proof you just said was there. That was in the answer.
Well, he says it was an early retirement. He took an early retirement in February of 2020.
That doesn't mean that that's not the same as testifying, I don't plan on finding a job someplace else, is it?
I don't think there was any proof that he attempted to find work
No,
elsewhere.
he apparently decided not to.
Right, he didn't. And he thought in February of 2020 that he was taking early retirement.
But not necessarily that he wasn't going to be working elsewhere, from what you just read. He knew that he was taking early retirement.
Yes.
And that's what he answered. But where's the proof that he knew then that he wasn't going to be looking for another job?
I don't think he specifically says that, but I don't think in any point did he ever say that he applied to jobs
I agree.
or attempted to.
I agree.
I don't think there's anything to show that he had planned otherwise.
I don't know what he planned at that time, because we just don't know one way or another. He was asked that, but he didn't answer.
Right. He did not give a straight answer to it.
Well,
Yeah.
we're stuck with the answer that was there. Let me ask you some other questions about this. I mean, I'm pretty fascinated about this. He testified, correct?
Yes,
Your client did not.
correct.
They both submitted affidavits of expenses.
Yes, as is required under the local rules.
Yes. He was cross-examined on it.
Correct.
And the trial court said, no, you know, we're going to knock out some of the expenses. Your client, who didn't testify, the trial court just looks at her affidavit and says, oh, I'll accept all that. That's all reasonable. Why was her affidavit, you know, really? She didn't testify? So he's penalized for testifying. It seems to me he's penalized for testifying. She doesn't testify, so her affidavit is accepted completely. Does that seem quite right?
Well, it was Mr. Baker's burden to prove his case, and if he wanted to question her affidavit, he certainly had the right to call her and question it. And he chose not to. I don't know the reasons for that, but
And she chose not to.
I chose not to as well.
Yeah.
I didn't think that they had met their burden of proof. And her affidavit was in the record. I didn't see a need to call her.
All right, let me ask you some other questions. I have a lot
Okay.
of questions for you. I know you're thrilled to hear that.
Yes.
The trial court just allowed those expenses from the ex-husband that he said were documented. Basically, is that correct?
Yes,
$490 worth.
correct. He only allowed certain ones. I think Mr. Baker only provided proof of some home repairs and his cell phone bills.
Yeah. Nothing for food.
No, he did not.
Nothing for food. Is that correct?
Correct. He found that the food.
Nothing for clothes. Is that
No,
correct?
he did allow clothing for $100.
Oh, you're correct. He did. Nothing for food. Nothing for a place to live.
No, there was testimony that Mr. Baker lives with his wife. He didn't allow anything in his expenses.
Just answer.
Correct.
Yeah, correct. Nothing for a place to live because his current wife was paying it.
Correct.
I guess I'm also troubled by how the trial court says he has no expenses for food, even, just none. Yet your client, who has another adult living with her, is exempt from the statute that requires that. He's stuck because his current wife is paying for everything.
Well, I think, again, that's the totality of the circumstances. It's not maybe his expense, because he testified when he goes grocery shopping, she gives him money. When he needs food, she gives him money.
So since she's supporting him, he has no cost for expense, no food cost.
That's what he said. He said he had no debts.
And your client is either buying food for the adult that lives with her, or the adult is contributing.
I don't think there's any proof of either of those.
Well, the statute says that, doesn't it?
Right, but this court had previously found that she had the adult daughter with her, that there's not a change in circumstances and her situation, because she had always supported that child.
Did the adult daughter have your client's grandchildren there too? Was that found?
I don't know in 2017, but this court dispelled that notion in Covarrubias 1.
Would you agree that the ability to pay and the need of the recipient are the two main factors to be looked at?
Absolutely.
I mean, I understand
Yes.
it's got to be a material change of circumstances.
Yes, but when we get to the second prong, those are the two most important factors.
His income now is limited to $3,000 some odd dollars a month. Is that right?
I don't know the amount. I want to say it's $2,400 a month, 2,000. I don't think it's 3,000 a month. I think it's 2,000 and something a month.
Okay. $2,167 a
Yes.
month. That's his total income.
Yes.
and you think it's your position, that he still has the ability to pay.
Yes, that was his testimony, that even after he writes a check at the beginning of the month, he gets in his $2,000 a month, and he writes out 50% of that to my client, that he has never once had a problem paying his expenses. He has been able to pay every bill, every expense.
Because his current wife pays them all.
Yes, he says that she
All
keeps
right.
him up.
And your client has an excess of how much per month? Even taking her expenses as completely unchallenged, just accepting them as gospel.
It was around $300 a month on her affidavit. And there are plenty of cases that say her frugality and not spending should not punish her because she is she is saving money because she is nearing retirement age.
Okay. Was there testimony that she was living frugally?
No, but I think that can be shown by her affidavit.
Bill Gates probably saves money every month too. Lives less, but he probably doesn't live frugally.
Yes, but I think her affidavit shows she doesn't have an exorbitant amount of expenses. She doesn't have, there were some cases, I think the Malkin case that the husband went to France for 2 weeks every year and significant travel expenses. There's nothing like that on her affidavit.
What were her expenses on the affidavit total?
I don't know if I have that in front of me. She had groceries, she had housing, utilities, cell phone bill. I don't know that I have her affidavit in front of me. I apologize.
Well, I do too. I don't see it.
But the
Trial
court
court
took
said
her.
she has as much as I can't find it here, but says she has as much as $830.35 per month available to her beyond her current need.
That is after the trial court took into effect her tax refund from the prior year and averaged it out over 12 months.
Yeah, because the trial court found she had excess withholding.
Yes, correct. That was not what, her affidavit didn't show the $800 a month, but that's what the trial court calculated after taking into effect her tax refund.
Yeah.
Yes. I just want to hit very quickly, the trial court refused to award attorney's fees in this case. As the court in Henderson noted, absent a showing of modification proceeding that the need no longer exists, requiring the recipient to expend that support for legal fees incurred in defending it would defeat the purpose of public policy underlying the statute on support. Additionally, the possibility of being burdened with a former spouse's attorney's fees helps deter unwarranted, unjustified attempts by an obligor to evade or reduce an existing support obligation. This is the second time that we've been in this court, as well as being in the trial court and petitions for contempt, and so we're asking for my client to be awarded attorney's fees for having to defend this petition. I see my time is up unless there's more questions.
Okay, I hear that.
Thank you.
Thanks to counsel for both sides. We appreciate your argument and your briefs. Oh, I'm sorry. My mistake. We'll hear from the appellant in rebuttal. Yes.
I'll be very brief, Your Honor, I promise.
It's the end of the day for us too,
I understand. I've not had enough caffeine today at this point.
or for me anyway.
I'll try to be brief. Your Honor, I just want to draw the court's attention. I know it's in the record, but Mr. Baker testified specifically on page 61 of the transcript. The question was asked by myself, and this was on cross. And when you entered this order in July of 2020, while you were retired, were you certain what you were going to be getting into 7 months later? He asked me to repeat, and then I said again, were you certain what you were going to be doing 7 months later? And Mr. Baker replied, no, ma'am. So he was unsure of his plans post-severance package, early retirement. The other thing I want to draw the court's attention to, and I think I heard the court, and you guys have a strong understanding of this. Unlike an initial award of support and alimony, when you're deciding whether to modify or not, the need of the receiving spouse and the ability of the obligor to provide support must be given at least equal consideration. And in this case, there needs to be equal consideration given to Mr. Baker's needs and his ability to support his family and his lifestyle, and Ms. Covarrubias and her family. The other thing I want to point out, Ms. Breeding discussed about Ms. Covarrubias the last time they were in front of this court when it comes to the adult third party living there. That was before the Griffin versus Griffin case that just came out in October of 2022, which basically said we can't take into consideration as far as on monthly affidavit of income expenses, the way I read it, you can't take into consideration adult third-party children. And that was a case where there was a divorcing parties, and one party was supporting an adult child, and the court basically said, no, you can't take that into consideration.
Is that case referenced in your brief?
Yes, Your Honor.
Okay.
Griffin versus Griffin. It's referenced under, in my primary brief, on page 12 of my primary brief. I think those were just the last few closing points. Make sure I didn't miss anything. Briefly on attorney fees, there was no affidavit. I submitted an affidavit of attorney fees at the trial level on behalf of my client after the November 18th hearing. I did not see in the record an affidavit of attorney fees on the trial level for Ms. Covarrubias as it applied to this the November 2022 hearing and the order that came out December 6th of 2022. Thank you, Your Honors, for your time.
Thanks to both sides. Now we appreciate your arguments. I'm sorry for that. If you would adjourn court till tomorrow morning.